Hello and welcome to the IFPDA Foundation lecture series for Print Month. The IFPDA Foundation, just a little description, is a group that gives money to internships and grants. And if you feel like supporting it, it would be appreciated. So we thank you. Mary Weaver Chapin is president of the Print Council of America and curator of prints and drawings at the Portland Museum of Art in Oregon. She holds a BA from Wellesley College and earned a PhD from the Institute of Fine Arts, New York University. She's going to share a bit on the Print Council's program for the IFPDA's Print Month before handing the program over to Marie-Stéphanie Delamaire. Just a brief comment about Stephanie Delamaire. She is a friend. When she arrived at Winterthur, she brought with her a new view of American print, being trained in France in her craft, and therefore I believe she will bring a new perspective to her talk on Gilbert Stuart and the prints and copyright. Thank you,
Robert, for starting us off today and for that nice welcome. We are very much in the debt of the IFPDA for this marvelous month of programming. And I want to especially thank Jenny Gibbs and Sherry Young for coordinating a very complex schedule that is benefiting people all over the United States and Europe. I also want to thank you, Robert, for your work on the IFPDA Foundation Board. Our museum was a recipient of one of your generous grants, and we are so pleased with the work that you do. So thank you very much. Today, I am pleased to welcome you to the first of 3 presentations we're calling Themes and Variations, Topics from Print Council of America. The Print Council of America was founded in 1956 to foster the creation, dissemination, and appreciation of fine prints, old and new. Today, we continue this mission with a membership of approximately 300 curators, scholars, and conservators devoted to the graphic arts. For the next 3 Thursdays, Print Council members will present their research as part of Print Month. We are pleased to begin our series today with Marie-Stéphanie Delamaire. And next week, we will hear from Leslie Jones and Deborah Wood on Poetic Science, the Origins of Digital Printmaking. Our final presentation will feature Jennifer L. Roberts, Glenn Adamson, and Andrew Rafferty with a conversation on art and the pull of the print. Now, a few words of introduction for our speaker today. Marie-Stéphanie Delamaire is Associate Curator of Fine Arts at the Winterthur Museum, Garden, and Library, and an affiliated assistant professor at the University of Delaware Winterthur Program in American Material Culture. Her research interests include artistic encounters in the post-colonization period, printmaking, and the transnational art market. Dr. Delamaire is the author of several articles and book chapters on the circulation and appropriation of printed images. She is also the co-editor of Circulation and Control, Artistic Culture and Intellectual Property in the 19th Century, which I believe will be published this year. Marie-Stéphanie, thank you so much for joining us today. We are all eager to hear about Gilbert Stuart, the print trade, and the genesis of art as intellectual property in the United States. I'm going to turn the screen over to you now, and I will join you later for questions. Thank you, Marie-Stéphanie.
Thank you, Mary, and thank you, Robert, for this introduction. And I would like to thank the IFPDA and the Print Council of America for welcoming me and inviting me to share my research on intellectual property in the 18th century and 19th century. So in today's art world, the notion that artists, like authors, produce an intellectual property when they create an artwork is widely known, although it's also widely considered to be very complicated. Copyright is the area of law that regulates this private property in ideas and authorship. What kind of rights and protection does it provide? For how long? How can this property be sold or transferred? As we know, copyright not only impacts artists as creators, but also many individuals who might or might not work in close relation to the art world, from collectors to educators, scholars, publishers, dealers, museum professionals, and so forth. One of the most thing that I always think about, of course, as a scholar is if I'm going to use an artwork in any publication, the question is, do I need to get the appropriate authorizations? Yet copyright is a relatively recent historical development. It is an area of law that emerged in the early modern period within the trade for printed text. Copyright later expanded slowly to other areas of activities, in particular the visual arts. Some scholars have argued that in some ways at its core, copyright is about the commodification of ideas. In the United States, in the United States, the first general copyright statute was enacted in 1790, and the text closely followed the British antecedent of the 1710 British Statute of Anne. Although American legislators were certainly familiar with another British text, the Engraving Act of 1735, the 1790 American statute did not include what we would consider today the fine arts. Instead, it limited protection to maps, charts, and books. And on this screen, I've only put the elements that relate to the visual works. Paintings would not be protected by American copyright law until 1870. In contrast, historical prints, any print or engraving, photographs and their negatives, all benefited from copyright protection earlier in 1802, 1831, and 1865. Considering the fundamental role that imitation and copying played in artistic discourse and artistic practice during this formative period, and considering that until the last quarter of the 19th century, a printmaker's reputation was largely measured in relation to the making of images that adapted someone else's creative work to print, the early history of American copyright law seems rather inadequate because seemingly it protects the copy while leaving the original open to reproduction, appropriation, or any other form of unauthorized use. And yet, in spite of, or maybe because of the absence of statutory protection, the 19th century American art world was not an ungovernable free-for-all. Artists, publishers, patrons, and owners of paintings, they thought or they argued about what they owned. Was there any difference between possessing the object and owning its design or idea? Whose right should prevail? The right of the creator or the right of the purchaser of the work, or the right of the publisher? And in cases where disagreement arose, what ultimately held sway? Was it the law or the custom? These are some of the questions at the core of the public and legal battles in which Gilbert Stuart found himself as he tried to control the copying, the publishing, and the selling of his most well-known composition, the Portrait of George Washington. Exploring Gilbert Stuart's attempt to regulate the afterlives of these portraits as he multiplied them and strived to prevail as the dominant producer of high-end portraits of Washington, stretching the limits of the period's artistic practice of repetition to a breaking point. Exploring the painter's efforts shows that he was inspired by what he had experienced in the British print trade, an environment ripe for the emergence of a broad concept of abstract property in an artwork. But what that property entailed, or what that property consisted of, remained largely unresolved. So in 18th century Britain, leading painters asserted an entitlement to oversee the afterlife of their composition in print through contracts with dealers and engravers, in their relationships with patrons as well. It's a set of circumstances that made this situation possible. The first was the establishment of powerful art institutions, such as the Royal Academy, which promoted the status of painters as intellectual authors. The second, and most important, was the print trade. Indeed, painters had to rely on printmakers to produce fine reproductive prints that they would accept as proper expression of the original artwork in print. Therefore, they needed sophisticated printmakers who could successfully translate the painterly language of colors and brushwork into the graphic language of the burin, or in the tonal values of a mezzotint or a crayon engraving and other media, printed media that were elaborate during this period. By and large, the printing print trade became an important center for the production of such prints and satisfied this type of collaboration during the second half of the 18th century. The concept of printmaking and painting as a liberal art was critical to the emergence of painters' claim of authority over the reproduction of paintings in print. The well-known phrase, ut pictura poesis, as is painting, so is poetry, had become an influential concept in British art, leading, among other things, to the foundation of the Royal Academy in 1768. Several authors, in particular Charles-Alphonse Dufresnoy, Roger de Peale, and Jonathan Richardson, they all contributed to popularizing this intellectual status for painting. The influence of those authors even expressed itself in the language of the petition brought forth by William Hogarth, and which led to the first Copyright Act protecting the visual arts in Britain, the so-called Engravers Copyright Act of 1735. In the petition, engravers called attention to the genius of the artist, and they complained about the difficulty of exerting one's invention in the existing conditions of artistic creation in the print trade. I quote, "Seeing how vain it is to attempt anything new and improving, the artist bids farewell to accuracy, expression, invention, and everything that sets one artist above another." Invention and genius are two notions typically applied at that time to intellectual authors. The greater priority given to artists' intellectual qualities had a profound implication for their status as author, because genius was not nurtured in a workshop. Rather than a learned skill, it was fundamentally an innate quality and an abstract one, and one specific to one individual. And in that regard, it is important to note that William Hogarth, for example, he inscribed many of his plates with the Latin abbreviation or the English translation of invention. For example, what you see here in the Lottery or in the Southwark Fair. Artists were claiming the status of an author as a basis for the demand for copyright protection. Most importantly, it is in the relationship between a painting and its publication that showed the seed of an abstract notion of intellectual property in a painting. One publisher in particular, John Boydell, played an important role in this development. Boydell became one of the leading figures of the British art world, not only working as an engraver, as a publisher, and as a print seller, but also promoting contemporary British art in various ways. He commissioned and exhibited and published paintings by living artists. He donated works of art to public institutions. He developed a large network of patrons within elite circles, and he published their collections in print. He also held several public offices, which he used to promote public building renovations with ambitious artistic programs. But originally, Boydell had started as an engraver and as a print seller. Using his shop and his galleries, he distinguished himself from his peers by almost exclusively focusing on selling fine reproductive prints and by organizing large-scale exhibitions of leading painters, where he also offered subscription for the reproduction of their paintings. So how and why did he get there? At the beginning of his career, according to his own later recollections, he had to import most of his stock of reproductive prints from France. He had to pay cash for the imported prints because no print publisher on the other side of the channel at that time would accept British prints in exchange. There was no market for them. So this led him to develop a new strategy. He invested in the most promising young London engraver, such as William Willett, for example, or John Hall, to raise the quality of British reproductive prints and to level the playing field on the international market for fine prints. In order to do so, he considerably increased premiums paid to engravers, paying amounts for a single plate that had never been seen in England. And as a result, he secured the best available artists and encouraged them to dedicate time and energy to the adaptation of celebrated paintings into print. Boydell's strategy set new standards in the London print trade. He was soon able to offer quality engravings on par with foreign imports, which put him in a position to contract further with major painters and engravers for the reproduction of famous works by contemporary artists, such as The Death of General Wolfe by Benjamin West. More importantly, Boydell's publishing practices facilitated the growing role of reproductive print and emphasized high-profile commissions, exhibitions, and publications. So his promotion of quality reproductive prints converged with the art theory of the time that equated art making with intellectual authorship to clear a path for British painters' demand for authorial control in reproduction. For example, in a well-known anecdote, Benjamin West, which you see here on the left, expressed a strong sense of ownership that this relationship between print and painting brought about. The artist recalled a conversation with the naval hero Nelson that drove the point home. According to West, Nelson would have told him, "I never pass a print shop with your Death of Wolfe in the window without being struck by it." The painter's use of the possessive for The Death of General Wolfe clearly identifies himself as the intellectual author and proprietor of the artistic creation that is seen in the engraved image. Another example is John Singleton Copley, also an American-born painter established in London. Copley famously remarked that, I quote, "The difficulties of a painter began when his picture was finished, if an engraving from it should be his object." Yet, in spite of this cautious or wary attitude towards printmaking, the artist was deeply invested in the publication of his paintings. More than that, he was ready to go to court to pressure engravers to deliver the highest quality in the engraving, in a famous case that opposed him to the engraver Jean-Marie Delattre in 1801. Copley had commissioned the first plate of a large history painting from Bartolozzi at a price of 2,000 guineas, which is a huge amount of money. And he then commissioned a half plate from Delattre, but he refused to pay, arguing that it was poor workmanship. And there was a famous trial in which 14 engravers testified on behalf of Delattre, and then 14 painters testified on behalf of Copley. The jury decided in favor of Delattre, and Copley lost his case. But that didn't keep him from continuing to argue about control over the reproduction of his paintings. A dispute that arose between him a dispute that arose between him and the owners of one of his portraits sheds light on the way that he asserted an artist's right to control publication over those of the owners of the painting of the work itself. The quarrel never became public in that particular case. It arose after the death of the sitter in a portrait, the second Earl of Bessborough. The deceased family and friends wanted to honor his memory and approached Boydell to contract for the publication of the portrait. Possibly hearing about the project from the publisher himself, Copley immediately took action to stop this unauthorized publication, writing to the heir, "It is extremely uncommon for an engraving to be made from a picture without first consulting with the artist who has painted it. I did not make express agreement to secure myself from that inconvenience because I did not suppose it necessary. I certainly, however, expected that both copies which I painted would be considered as delivered from my possession with the implied condition of their not being published." It is clear that the painter's expectations did not rely on legal text, but rather on usage and conventions. Yet, what is interesting is that in spite of the heir's indignant response, and we could say, or think about also like the difference in terms of social standing between an artist and an aristocrat, the painter's point of view prevailed. Boydell recommended that the family's publication project be abandoned, and Copley commissioned his own print and registered its copyright. Supported by the Engravers Act, prominent art institutions, which advance the intellectual status of artists as creators, and by the changes that Boydell's business practices brought about in the print trade, painters like Copley or West bestowed their creative authorship onto reproductive prints by talented engravers such as William Woollett or Francisco Bartolozzi, who moved to London to become engraver to the king. They envisioned new rights as creators of visual work. The new Engraving Act of 1766 in Britain expanded copyright protection to reproductive prints specifically, and opened that protection to publishers as well as to artists. This extended engraving right affected the way British painters claimed intellectual ownership over their paintings in printed work. It also is clear that highly visible commissions, exhibitions, and partnerships with famous artists, engravers, and publishers like Boydell conferred privileges to a painter such as the customary right to authorize an engraving or not, even if the painting had been sold and left the studio. Disputes certainly arose, as we saw, between painters and engravers, as well as between owners of a work of art and its author. The traces that they have left in the archive nevertheless suggest that many elements for a broad concept of intellectual property in a visual work could be found in the late Georgian print world. A detachment between artistic authorship and the medium in which it was expressed, statutory legislation that allowed artist authors to claim proprietorship over an image in a published version, and powerful art institutions and trade partners that supported them. But it is in the unregulated and underdeveloped outworld of the United States that an artist, Gilbert Stuart, would take that step. So Gilbert Stuart came of age as an artist in the London art world I have just described. He was born in Newport, Rhode Island, and he moved to London in 1775. In London, he trained in the studio of Benjamin West, and he quickly became a rising star. His breakthrough painting was The Skater, a portrait of Sir William Grant, exhibited with great acclaim at the Royal Academy in 1782. But Gilbert Stuart was also profoundly tied, his career was also profoundly tied to Boydell and to the publisher's ambitious programs. One of the earliest commissions after he left West's studio was a series of portraits of painters and engravers commissioned by Boydell for exhibition. Part of this commission, Stuart's portrait of Benjamin West and his portrait of the engraver William Woollett, call attention to the close relationship between the two artists for a successful reproduction. Woollett was one of the most sought-after engravers in London, and his most renowned plate was the engraving after West's The Death of General Wolfe, which is represented in the picture. Stuart's portrait shows the engraver at work on this very famous plate, directly with the painting in the background, emphasizing the intimate relationship between the painter's work and the engraver. Whereas in fact, probably Woollett would have probably much more likely worked with a drawing than with the painting. In London, Stuart maintained an extravagant lifestyle that kept him in an increasing amount of debt. Eventually, threatened by the dismal state of his financial affairs, he fled to Ireland and then to America, where he arrived in 1794 with the explicit goal of regaining financial stability by painting George Washington. He wrote, "I expect to make a fortune by Washington alone. I calculate upon making a plurality of his portraits, and if I should be fortunate, I will repay my English and Irish creditors." Stuart correctly assessed the market for the likeness of the first president in the US. With several commissions for the anticipated portrait, a letter of introduction, he settled in Germantown near Philadelphia to paint the first version of Washington's now famous likeness. This is the Vaughan portrait type, a waist-length portrait showing the right side of the president's face. About a year later, the president sat for the artist a second time. The portrait that resulted from this sitting, also waist-length, is the most iconic representation of Washington. Intentionally left unfinished, it is called the Athenian Portrait and became the basis for about 100 or so copies, and the engraving we have on the $1 bill. Finally, Stuart painted a third type, the full-length portrait, called after Lord Lansdowne, for whom it was commissioned by Philadelphia merchant William Bingham. And there are 4 known copies of this composition. At first, painting Washington proved to be the very successful business Stuart had hoped for. Stretching the practice of repeating a successful composition to untested limits, the artist had a list of 39 patrons for his Washingtons within a year of the first sitting. We know that he was selling the waist-length portrait for about $150 a piece, which was very expensive for the time in America. And for the large full-length portrait, he received $1,000 from Bingham. Everything was going smoothly until the spring of 1800. First, Stuart stumbled upon an unauthorized engraving after the Lansdowne portrait in the city's print shop. And second, the Connecticut, a merchant ship that landed in Philadelphia in April of 1802, brought into the city above 100 full-size Athenian-type portraits of Washington painted on glass in China. John Sword, the captain of the Connecticut, was a patron of Stuart. He had purchased a waist-length portrait a year before. Active in the Atlantic and China trade, Sword had no doubt realized the potential for profits to be made with a luxury work of art representing the first president. Bringing the portrait to Guangzhou, he commissioned his copies of the technique of reverse painting on glass and brought it to the US, where he, of course, hoped for a handsome return. Likely one of the portraits that survived the following lawsuit, the beautifully crafted Chinese replica that you see on the right, gives us a good sense of the danger that such objects presented for the artist's livelihood. It's a full-size copy of the original work, painted on a 25 by 30-inch sheet of glass. Its material, of course, would prevent any purchaser from mistaking it for Stuart's original, yet it belonged to a category of sumptuous exotic goods coming on the American market at a fast rate at that time, and its identical size would make it much closer substitute for Stuart's painting than the large and unauthorized engraving of the Lansdowne portrait. Stuart reacted quickly to these 2 major threats. First, he launched a public campaign against the unauthorized engraving. And second, he filed a lawsuit against Captain Sword. For his litigation against Sword, Stuart received legal advice from well-established members of the Philadelphia bar, who were all among his patrons: Alexander James Dallas, William Lewis, William Rawle, and William Tilghman, were all known for their sympathy for the rights of British citizens, and Stuart at that time remained a British subject. They all commissioned and purchased works of art from Stuart, and at least one of them, William Rawle, had more than a casual interest in the role of the visual arts in the United States. He would be one of the, among the group of people who were instrumental in the foundation of the Pennsylvania Academy for the Fine Arts. There isn't much detail in the archive, and it is a bit unclear under what terms Stuart eventually won his case at court. In his bill against the sea captain, however, the painter explained with much detail that he had sold his paintings to Sword with explicit restrictions regarding the buyer's right to have the painting copied. The bill Stuart presented to the court also expressed a concern that his claim would not find sufficient remedies at common law. So I need to be a little technical here so that we understand the concerns of the painter and his strategy to obtain what he needed. He needed the destruction of the unauthorized copies. And at that time, common law remedies gave the plaintiff the possibility to recover costs equivalent to damages that could be proven. And there are no records of how many of the portraits actually sold, and there are no advertisement for them either. So we don't know how much Sword planned to ask for them. Common law remedies also did not permit the confiscation of fraudulent copies. Scholars have estimated the total output of Stuart's Washington portraits slightly above 100, so a quantity very close to the number of Sword's Chinese copies. What we do know then is that over the course of a few months, Sword was throwing on the market an equivalent of the painter's livelihood. The sheer quantity of paintings imported by Sword was a major threat to the artist's business, and their forfeiture was clearly his goal. Stuart therefore requested remedies that the Court of Chancery in England could issue, that is, an injunction ordering the delivery and the destruction of the fraudulent copies. Stuart's case was resolved in favor of the painter, showing that the court likely accepted the validity of the painting's contractual sale, together with its limitation on copying. There's no written record of what happened to the 100 or so paintings on glass. Captain Sword was requested not only to cease selling the unauthorized copies, but also to have them ready for the court's further instructions, suggesting forthcoming seizure or destruction. Before his dispute with Sword, Stuart had also launched a public campaign against the unauthorized print for sale in Philadelphia. In this campaign, he clarified what he thought were his rights in his artistic creation, articulating the connection between restriction on publishing and an artist-author's intellectual property in the work of art. He sent to the paper a long article complaining about the publication of the British print, in which he said, "Mr. Stuart has the mortification to observe that without any regard to his property or to his feelings as an artist, an engraving has recently been published in England and is now offered for sale in America, copied from one of his portraits of General Washington. Though Mr. Stuart cannot complain of this invasion of his copyright, a right always held sacred to the artist and expressly reserved on this occasion as a provision for a numerous family, he derives some consolation from remarking that the manner of executing Mr. Heath's engraving cannot satisfy or supersede the public claim for a correct representation of the American patriot." And we can see how actually he doesn't in some way have any right, because there's no copyright, extant copyright on painting, neither in England, neither in America at that time. But when he demanded that the Philadelphia merchant William Bingham do not cede his publication right together with a full-length portrait of Washington, Stuart was just following very well-established practices of the British print trade. The painter's preoccupation with controlling the engraving after his painting and with reaping the benefit of adapting one's painting in print tied him to the British art world. In London, where he trained, Stuart's peers, such as Benjamin West, as we saw, John Singleton Copley, had formed alliances with publishers and with engravers to exert authorial control over the publication and circulation of their paintings in print. Clearly, benefiting financially from one's creative work was part, but not necessarily the full objective. As Stuart's bill and newspaper articles explained, ultimately, it was a matter of property in one's creative work. The painter's use of the notion of property to define the object of his claim and the term copyright in association with this claim was something entirely new. Stuart's denunciation of Heath's engraving and his litigation against Captain Sword demonstrate that the artist did not defend the right to control who and when a painting might be engraved, a publication right, if you will, but a broader intangible property inherent in one's work and which implied a right to control copying, to control publication in all media available prior to and following the sale of the artwork within and outside the boundaries of the nation state. This was a very bold claim indeed for that time period, and one that was obviously not easy to enforce in the United States, where there was no powerful artist body like the Royal Academy or respected and connected publisher like Boydell to set the rules and enforce a code of best practices between creators, publishers, and their patrons. In contrast to Britain, the American art market and publishing industry did not offer much in terms of institutional and customary regulation. But Stuart's ability to leverage his patrons' network to succeed in court equally proves that his idea could find traction and that it could be defended using contractual sale, for instance. So even though the court case Stuart versus Sword was not reported in the legal literature at the time, there is little doubt that Stuart's bold conception of intellectual property in a work of art had a profound impact on the next generation of artists working in the United States. Stuart never returned to Britain and likely never repaid his English and Irish creditors. Nevertheless, he became a founding figure for young artists who sought him out for advice and instruction. One of them, John Nagel, would become the director of the Pennsylvania Academy for the Fine Arts. He recalled discussing these events, and he reported the inappropriate conduct of a patron like Bingham and how Stuart had been deprived of his property in the painting to the author William Dunlap. And it was published in Dunlap's chapter on Stuart in 1834. A decade later, when there was still no legislation on the copyright of paintings in the United States, another painter, William Sidney Mount, privately commented on being compensated for the copyright of The Power of Music when contracting for its publication with the newly established French dealer and publisher, Peale and Company. The difficulties that Stuart encountered with the appearance of an unauthorized print in Philadelphia made abroad, or with the relatively new medium of Chinese reverse painting on glass, and the medium itself was not that new, but what was new is the way that it was really connected to the US market at that time. This in some way can be seen as a preview of what was to come with a series of revolutions in the production and circulation of new visual media of the 19th century. In the advent of the industrial image and the proliferation of reproductions in media that accompanied it, the reproductive print, which had taken pride of place in many of the most important printmakers' career, slowly lost its status. But it is through their production in artistic centers, such as the 18th century London, or through the relationships that were established or disputed between artist painters and artist printmakers, their dealers and publishers, and their patrons, that Stuart's broad concept of intellectual property in a visual work found its root. This notion of artistic property was entirely independent from the medium and state in which the work was created. It anticipated some of the key questions and development that would lead to the expansion of copyright protection first to new media as they appeared throughout the century, but more importantly, later, to a very broad expression, to a single expression derived from the work, no matter the medium. And this had a profound impact on the way we work today and on the way we think about what it means to create a work of art and what it means to own it. Thank you.
Marie-Stéphanie, thank you so much. What a fascinating journey that took us from England to Ireland to the United States, and the really surprising connection to China. What a wonderful path. If you are willing, we'd love to ask you a few questions about your work.
Sure.
One question I have was that you talk about Gilbert Stuart's influence for this next generation of artists. Who are some of the people who kind of took up that mantle? Are there any names that were particularly vocal about continuing his copyright work? Or do you feel like he accomplished what he had set out to do in his own lifetime?
I think so. So in some ways, what is interesting about the American market is that not many artists decided to sort of lobby with Congress to get paintings part of the copyright legislation, which was a little bit surprising to me, considering how in private matters and in publication they talked about it. There is one exception. It's Rembrandt Peale, the son of Charles Wilson Peale, who had worked also in England and worked in Paris. So he's the one who, interestingly, also lobbied Congress for the protection of another Washington painting, actually. And it didn't work. And that's one of the things that I'm hoping to look a little bit more into. And I think it relates to a question that sort I didn't talk about here because it didn't come up in the discussion, but basically the likeness of someone, is it something that could be owned or copyrighted? Like something that didn't come up at all here is that whether the sitter himself would have a right to decide, right? Like today we think that, you know, we ask people to give authorization to get their pictures taken. And that was not something that was an issue at the time, right? But so it was like the sitter and a portrait, since it's a representation, supposedly a likeness of someone, was that the property of art or the domain of art, right? So that's also a question that was not resolved at the time.
Oh, that's fascinating. I hope we can count on you to tell us more about that in a future publication. Marie-Stéphanie said, but lots of our print council friends are here today, and we have a question from Julie Melby. She wants to know if Gilbert Stuart was ever compensated for his design on the $1 bill.
That's another good question. I don't know. I don't think so. I don't know when it started being the $1 bill image. That's a very good question. I'll have to look for an answer to that. But at the time, the limitation. So what is interesting though is that after all these adventures with the print and the painting on glass, he collaborated with an engraver to copyright his own print of, and so he's one of the first artists to deposit a copyright, a print for copyright protection in 1803, and it's a portrait of Washington, of course, but it's not the one that appears on the $1 bill.
Excellent. You know, one thing that really astounded me was the concept that artists could litigate against the owners of their work or their patrons. Was that something that happened regularly, or was that more of an exception?
Well, so I think in the 18th, so technically this is all, I think there's no, well, yes and no, right? There, in some ways, there is no real basis for it, in a sense that I think I think probably, though there's very little in the archive, right? And as I've been doing this research also a lot in the past 18 months, for example, I know that there is a case in Britain that happened in the 1760s that was also about a portrait, but I was not able to go to Britain and to see what was in the archive, unfortunately. So that is something that I hope to do one day. But so I think it's mostly sort of best practices that were enforced without any legal ground. So it's also another aspect that interests me, is how, in fact, in the absence of protection that could be enforced legally, then people came up with their own rules that they try to promote one way or another, whether it's with printmakers or things like that.
That must be a fascinating period when people are just trying different strategies to see what will stick. Sort of a messy process.
Yeah, and I think the entire period of the 19th century is like, I mean, the 18th century, in the 18th century, I think that in London, they really had come up with like a system that sort of worked, even though there were disputes, right? So not everybody agreed, obviously, about what you could do and what you couldn't do. But as the 19th century went on with, I'm thinking lithography, chromolithography, photography, also the photomechanical processes, and the new and the expansion of the public and the expansion of the circulation of images. So basically, who could do what with a work of art was incredibly a murky space, right? And so people tried different things, and sometimes it ended up in litigation, and sometimes there were other ways to try to enforce what the artists or owners thought that was a proper behavior vis-a-vis an image.
Oh, that's wonderful. Another question has come in from an anonymous attendee who asks, was there an issue of displaying the original artist's name too for free publicity? So I wonder if they're saying that, would they try to capitalize, say, on Gilbert Stuart's name with their work?
Like, let's say, Gilbert Stuart in the United States is definitely like a big deal, right? I mean, he has a great reputation. He has also a personality that does that. He's a flamboyant kind of artist. And so, for example, one question would be, to what extent, I mean, as I understand the question, that can be a little bit like, to what extent is Stuart not using, let's say, he's upset about seeing the engraving for sale in Philadelphia, but then he might be thinking also, well, that might be a way to make more publicity for me, right? For my work, for how unique, well, 100 copies is not that unique anymore, but how extraordinary his paintings are. And so, yeah, maybe there was part of that too. It's right. It's a bit, I think it's an interesting possibility. Let's put it like that. In the case of the Chinese reverse painting on glass, I do think that that was a major threat for him. And that, yeah, that was, and actually it didn't make it to papers or anything like that. It was entirely private. Probably he did not want to have those things advertised. And I couldn't find any advertisement for the painting themselves. I think probably also means that he tried to sort of like act as quickly as possible, take it down, and it worked, because there are very few of them left, actually. I don't know what
we saw today was from Winterthur, is that right?
Yeah, that's kind of why I started looking into this.
Okay,
actually.
That's great. Yeah, the origin of this. We have another question with a legal bent from Richard Candy. He says that it sounds as if Stuart claimed contract law to be the source of limits to what an owner could do without his approval. And certainly contract law has a prior history. So I see you nodding. Is that part of the discourse here?
Well, I mean, for me, of course, so I was really interested in this idea of ownership in art, right? And what it meant. So I'm not a specialist of law. I was never trained in law. I did get advice from several scholars, legal scholars, and that seems like that's their interpretation. I mean, there's very little, right? It's only a petition, and the fact that, and there's a small note that tells SOAR to basically cease and desist in some way, and then wait for further instructions. So that's and for example, I was wondering if Gilbert Stuart had any proof of that contract in the first place. So maybe, and I was thinking, because, it's one, then it's like a voice of someone against a voice another, right? And so he got very good counsel right away. He leveraged his network there. And he, so I don't know if he had made John Sword sign something, and then if he could prove that as a, because, how do you prove the contractual sale itself, right? To me, that's a question that I have no answer for. But yeah, I think it's a contractual issue. But so at that time, you don't have legislation on one hand, but maybe you can use something else to get what you want, right?
Yes. Yeah.
That's again, right? It's like it doesn't exist. Therefore, I'm gonna try to like I'm the right. Let's say I'm the artist. I think that I have a certain right with my intellectual property. Therefore, I'm going to do what I can to enforce it, even if there is no law about it.
Marie-Stéphanie, I'd like to circle back to what you said just a moment ago about how the Chinese copy sparked your interest. Can you tell us a little bit about your path into this research? I see it took you in all sorts of different directions, to legal publications, to looking for advertisements. I'd love to hear a little bit about how you first kind of got into this question and where it led you.
So it sort of brings two interests of mine. I'm always interested in the way that works of art circulate in the world, right? And their long history over distances that can be temporal distances and geographical distances. And so I see them also as objects that carry particular histories of encounters between cultures. So when I saw that painting, and I looked into the file and I realized it'd been made in Guangzhou, I thought, this is like super interesting to think about this object. So you have like I didn't even know why I thought it was a painting considering the size. It's exactly the same size as the Stuart painting, but I thought, it's interesting how this painting went all the way there to come back here. And then one of the things that has always also fascinated me is the multiplication of images and its impact on the way that we think, not only about originality, right? Even though, I mean, of course, it's a big topic in the 19th century, which is like, but more about that process of adaptation to something new, and especially when it implies negotiations one way or another. So I found an article that was mentioning that it called it a copyright litigation, which at the end of the day, it's not, right? It's probably much more likely a contractual litigation. Mm-hmm. But I thought it asked a lot of questions about, so who owns what? Who has the right to represent who, and who has the right to sell a work of art where, right? Like there are like geographical boundaries that are at stake, ownership ideas about work of art. And I think it's, at the end of the day also, if I own a Gilbert Stuart, I will not feel the same way as if I own even like an excellent digital photograph of it, right? Even if it was printed in 3D. And so I think even like with a print, for example, if a print exists in multiple, right? But there is something a bit different. If I own a book, I know that I don't own the work of the author, right? I think it's a little bit, even if there's copyright that we are all aware of, I think when it's works of art, it's a little bit more complicated.
And I think it's a wonderful analogy. Yes. Marie-Stéphanie, can you tell us a little bit, will you be publishing this in your forthcoming book, Circulation and Control, or can you tell us what to expect in that volume? Is it, you told me it was coming out in 2021. Is it here, or is it just about here?
Actually, I think it's just came out yesterday.
Congratulations. Marvelous.
So yeah, it's the, I have an extended version of that talk in the book, and the book looks at the 19th century more, like it has like basically 2 chapters on the 18th century. One of them, so it's a book with it's an interdisciplinary book with art historians and legal historians and historians of publishing, and there is also like, so there are 2 chapters on the 18th century, including one that's about Elizabeth Blackwell, who was a printmaker of the 18th. The first she's the first one to bring a case of copyright infringement in England, and she's a woman printmaker, so it's a fascinating story. And then it goes, so it looks at the. We decided to limit it to Britain and the United States and the colonies. So we also have a chapter on what's happening in New Zealand in the 19th century. And we look at all the different kinds of media that are coming out in the 19th century and how people are negotiating these issues.
Oh, that sounds wonderful. And let me repeat the name of your book here, and maybe I can ask one of my co-panelists to type it into the chat. It's entitled Circulation and Control: Artistic Culture and Intellectual Property in the 19th Century. And I think that will be of great interest to many of the folks listening today. Your talk brought up so many wonderful, rich questions that I'd love to read slowly and ponder in time. And we're so grateful to you for sharing your work today. I think that kind of wraps up our questions. And I want to thank you so much, Marie-Stéphanie, for being with us, and to Jenny Gibbs, who's back on the screen to tell us about what more we can expect. Thank you both.
Oh, thank you,
you.
Mary Weaver Chapin. Thank you, Marie-Stéphanie Delamaire. And thank you to all the members of the Print Council of America for this really fascinating conversation today, which has given me so many thoughts for further research. Tomorrow, we hope that you can join us for a studio visit with Felix Harlan at Harlan and Weaver and special guest Kiki Smith. Tomorrow is also the opening of the IFPDA Fair online with 108 beautifully curated booths. Thank you again for your time and for joining us today, and we hope to see you tomorrow.